Justice Jackson?
I guess I'm still struggling to understand why the state would have to have perfectly tailored laws. I would think the state would just have to make exceptions where people can demonstrate that the justification that makes the state's conduct constitutional doesn't apply to them.
Right. So making exceptions is tailoring your law. That's literally what it means to tailor.
No, but
law.
from the standpoint of a facial challenge, when we're asking whether this law has to be stricken completely because it isn't, perfectly tailored. What we're doing is a different exercise in the as-applied challenge. We're asking whether, even though this law is overbroad, we're assuming it's overbroad now because you've got in there some people to whom it should not be applied. What do we do about that? What is the remedy that those people can get? And what I hear you saying is they get no remedy unless they can demonstrate that there are enough people that this is sufficiently overbroad that it's no longer something the state can do.
Right.
And I don't understand why that is. Why wouldn't, when we identify people for whom this law operates unconstitutionally, that's the premise, because now I'm in remedy, right? The premise is that you have a person who's successfully made an as-applied challenge. This, to me, unconstitutional. You say, too bad, unless you can show that it's also unconstitutional with respect to a sizable number of other people. And I don't understand why that's the case.
Because I don't agree with the premise that the law operates unconstitutionally as to an individual person just because it doesn't, the justification for the law doesn't apply to that person. That's what this court held in both Wynne and Michael M. It recognized that the justification that was put forward for the law might not be true for each and every person the law applied to, but this court said that's fine.
And if we read Caban and Lair to say something different, if I disagree with you, then we just...
Well, Wynne is the most recent of the cases. So
okay.
Even if you read the cases that way, and Wynne is explicit about this. Wynne explicitly says, I believe it's, I'm not going to get the page number right, but Wynne explicitly says that we recognize that there are some men who were present at the birth of their child, who have a DNA test to prove that they were the father, that have been with their kids their entire life.
Yeah.
In fact, that was probably true of Wynne's father. Tough luck.
Okay, so Justice Barrett is worried, I think she said, about the implications of allowing as-applied challenges. I guess I am worried about the implications of not, because as Justice Kagan said, we have consistently said that facial challenges are really hard to get, that as-applied is really all there is. So now we're in a world in which you are setting up new barriers, in my view, to establishing an as-applied challenge. So at the end of the day, is your position that no matter how clear it is that the particular prescription is operating to disadvantage a particular group, that classifies you, treats you differently, you're just not going to be able to get a remedy for that individually anymore.
Let me take a step back, and then maybe this will help. Laws that classify, in general, are subject to rational basis review. Now, there's higher scrutiny for classifications on some things. For race, we have strict scrutiny. For sex, we only have intermediate scrutiny. What that means is it is okay to have a classification that doesn't operate perfectly for each and every person. So it's not the problem is that it's unconstitutional, but there's no remedy. The point is that it is constitutional,
I don't necessarily
even though
think
it's
that's
overbroad.
the takeaway. I think what that means is it's okay because we realize that in some circumstances, maybe even in many circumstances, this classification is justified. But when we can identify a situation in which it's not, I don't understand why a person can't bring that challenge.
Well, I can't say anything better than in both Michael M. and Wynne, the court recognized that there were people who it wasn't tailored for and they didn't give them a remedy.
Thank you.